We go on the record in pages 12 and 13. I Meta Holding versus Meta Platforms 877-867. Councils, can I have your appearances, please?
Yes, good morning, Your Honor. Todd, Bice, and Daniel Brady on behalf of the plaintiff and counter defense.
Good morning, Your Honor. Dan Waite on behalf of the defendant, Meta Platforms, Inc. With me today, admitted Pro Hoc Vitae, is Dennis Wilson here to my right. He'll be handling the remainder of this morning. Colin Zimmerman is also here. We have a client representative, Ms. Catherine Duvall. And also, Your Honor, I'd like to introduce you to one of our brand new summer law clerks, Ian Ogilvie. If you know George, this is his son. Thank you.
Congratulations. Welcome, everyone. Is anyone remotely on with either of you all? The reason why I have a trial right afterwards. In fact, our marshal's checking on our jurors down the hall as we speak. And so does anyone else need to be introduced? Are we good?
Mr. Schwartz, Your Honor, on behalf of the plaintiff, is on.
Okay.
Thank you.
And Ms. Gaudreau is on with us, but she's not making an appearance.
Okay. No worries. I just didn't want to ignore anyone. If anybody was on remotely, A, and B, I will give the friendly reminder on this case, which, like I mentioned, is case number 877-867, I Meta Holdings versus Meta Platforms, Inc. This case does have a media request. We do have the media individual here in the courtroom. There was no additional media request. That means anybody who's appearing remotely, the same rules, general rules apply, which means you're more than welcome. It's a public courtroom. But the only thing we ask is that you keep yourselves on mute, and you have to follow the general rules as if you were here in court without a media request, which would mean that you may not record. Because, sir, you're the only person from your entity, right? Pursuant to the media request.
We have Dory online for our event judges. Also, Daniel Downs for our
okay. Are you both recording or just one?
I'm recording in person. They are recording online.
Okay, then let me make a caveat to what I just said, because I usually see one person, one recording. Okay. Well, obviously, yeah, our Nevada judges does have a media request, so whether it's one or two people recording, that's perfectly fine. I just meant anybody who does not have a media request would not be able to record, because you have the same options to have done a media request if it was appropriate. And that's the only one we have. And that's for this case. Our trial will be starting thereafter. So if you're on for our trial, that's going to be starting after we complete this matter. So today is the day for your mandatory Rule 16 conference, which, as you know, is the procedural aspect. You got a nice long list of different topics we can discuss. I will tell you, would it be of assistance? It's probably not coming out until tomorrow. It's being finalized, formalized. The court took the proposed orders that we got. I created my own. Do you all want to know what the net sum result is, or do you want to stay tuned when you get the long version in writing?
We're fine knowing the net sum result, Your Honor.
We are too, Your Honor.
Okay. The court, for the detailed reasons, ended up denying the motion for the preliminary injunction. You're going to get the detailed order. Like I said, we're working through in between trial and everything else, which you all know because you're on a lot of my other cases. Just needing to get some of those details and various typing done and some cross checks, but that's the net sum of it. See all the analysis that's going to be in that. Yes, I did utilize, thank you for the proposed from each side, utilized a lot of that information and trying to expedite to get that to you. Okay, so let's get, so the reason why I didn't know if you wanted to know, because for purposes of your trial dates and other dates, obviously that might impact whether you were thinking how quickly or not how quickly. This is a B case, which means B cases generally have some level of priorities under 1.61. We looked at your JCCR, other than you have your rebuttal expert disclosure. If you do, first off, do you want to adopt the dates in your JCCR, which would put you at a trial stack, 5-week stack commencing June 30th, 2025. Quick translation for those who may not be as familiar. We do stacks. We can do multiple cases any given week, and it's a 5-week stack. So that June stack happens to start June 30th. It gets triggered by the closest stack to your dispositive motion deadline. And so if we were to adopt the dates in your JCCR, that would put you on the trial stack of June 30th, 2025. But between the time you did your JCCR and today, don't know if you have some changes or thoughts. There's one change the court would do is, if you do wish to adopt, I would need to modify one of your dates, because January 19th, 2025, which you put for your rebuttal expert dates, is a Sunday, which while I may be working on a Sunday, you can't actually, and then actually Monday happens to be President's Day, so we'd have to change the 119 to be 121, but that's 2 days. I don't think that makes a difference to anybody. So circling back to what I stated was going to be my first question, do you wish to adopt the dates in your joint case conference report, or do you wish to discuss new dates? Counsel for plaintiff.
No, Your Honor, we'll adopt the dates that previously agreed to, subject to the modifications you just outlined.
Counsel for defense.
The same. We'll adopt all of those with the modification.
Okay, so then here would be your dates. We show you've estimated a jury trial for approximately 10 days. You've done, that would be motions to amend 12/19/2024, which would be the same date for initial experts. Your rebuttal experts would be January 21, 2025. We would have a discovery cutoff 3/19/2025. Your dispositive motion cutoff 4/18/2025. Motions eliminate 5/5/2025. Pretrial conference 5/29/2025. Calendar call, depending on where you go in the stack, but I'm going to give you the date that's triggered to the beginning of the stack because that's what we do. But oftentimes at pretrial conferences, if you're later in the stack, then oftentimes people may request a calendar call be closer to your actual trial date. Your calendar call currently, though, would be 6/17/2025 with a 5-week trial stack starting June 30th, 2025. Counsel, you like to be here the July 4th week, it seems. Oh, I'm just saying, but it's a 5-week stack. So that June 30th, 2025 stack starts June 30th and goes through goes through August 1st, 2025, which means we put that in. And depending on the length of the case, we do appreciate, obviously we multi-stack, business and CD have some preferences, and other preferential cases may come up before then and now. So that's with those dates. Motion eliminates we do based on when the trial date is. That's the reason why we give you a motion eliminate date. We do that motion eliminate date a little bit different. It gives the court's discretion. We give you a fixed date. We do it so there's enough time to hear the motions eliminate realistically before trial so people can get all their exhibits. So if you look at the rules, they give some options there, and that's what we do there. The next thing that the court normally would go forward with is to walk through to see if you all wish a settlement conference or mediation. When the court uses the term settlement conference / mediation, that means utilizing any entity that you want. The court does have, since this is a business court case, what we do is business court judges agree to hear mediations for each other, which means any of the other 5 business court judges could hear the mediation. You're not limited to those 5 judges. It's just we give a whole series of dates during the different years, and when those mediations can take place, we hear each other's. Generally, a lot of people have set aside certain Mondays or Fridays, but sometimes there's other dates. Other options is Department 30. We have a court process where any judge signs up to agree to do settlement conferences. Those are 2 of the ones internally within the court. There's a third option, which involves utilizing senior judges. That's a little bit more complex. There's certain requirements that forms that have to be filled out and go through different levels of processing, if that's an option. And then, of course, you can utilize any third party that you choose at your own expense. Those are not mandatory. I will tell you, oftentimes in business court cases, and also when you have sophisticated litigators and things like this, is helpful to do a settlement conference / mediation. But generally, it's helpful if you all have engaged in some discussions initially before doing that, because that way it makes it more productive. A settlement conference mediation can be set anytime. You all can say you want a no later than date. That's what we give as a no later than date. You can always do it earlier. It can be as late as the discovery cutoff. We don't set settlement conference / mediations in your trial order any later than the discovery cutoff, because realistically it impacts the ability to go to trial because of exhibits, all the witnesses, all those different things. So the first question is, would you all be interested in a mediation settlement conference? And I will tell you, if there's some inclination and you need the court to order it, then the court's always glad to order it. If there's not, then we don't generally do it at this early stage. This isn't one of those cases that the court would independently find that it would require the court's intervention. This is a little bit more discretionary. Counsel for plaintiffs, do you have some thoughts?
Your Honor, I guess what I would say is we'll take a look at your order once it comes out, and then I can confer with the defense side, and we can see whether or not we think it would be assistance, and then we can be back to the court in fairly short order, I would think.
I agree, Your Honor, that works for us.
Yes, it's getting away because, as you know, I'm gonna leave it to you. Sometimes the court would walk through the processes of sometimes having it in the court order, explains to the clients, look, it's coming from the court, but you all know that, so I'm gonna leave it there. Status check. I'm inclined to do a couple of status checks in this case so that we just keep moving. But before I do that, let me circle back. Do you all anticipate 10 days is really what is going to be on a jury trial in this case?
My track record with the court right now on estimating the number of days for hearings is not very good, so I don't want to hem myself into a corner. So I'm going to stick with 10 for right now, Your Honor. I think that is the outside amount, but you know,
No worries.
I've been here with you for the last 2 months, having to ask you for additional days on some things. So I'd like to leave it at 10 if we could for right now.
Counsel?
Be great.
Okay, no worries. It's usually, as you know, the longer cases that we have more of a concern of, because we want to make sure people are getting all the all cases we want to give everyone the appropriate time, but longer cases are a little bit more challenging for scheduling. Okay, so I was thinking, as far as status checks, is to do one status check as early as you want, but realistically, I was thinking late November, early December for a status check, and then obviously you have the opportunity if you need something beforehand, and then doing another status check close to your dispositive motion deadline, which would be late March to early April. So first off, the thoughts, do you, for some reason, not think that we should do 2 status checks? We should only have 1, or does 2 sound like a good thing? And if you have a time frame that's different than the courts, or if you like the court's suggestions, then tell me, maybe you don't want to do Thanksgiving week because maybe people want to be otherwise. Or give me kind of a proposed date or time thoughts. Go ahead, Counsel for Plaintiff.
Thank you, Your Honor. I'm fine with 2. I actually think they're productive. But we do have a fair number of out-of-state counsel here. So if we could avoid Thanksgiving week, I would ask that the court do that. Not just as a courtesy to them, but as a courtesy to myself as well. So thank you.
Okay, so you'd want more like November 19th or do December 3rd or 10th? Is that what you're thinking?
We have a couple of dates, Your Honor, in December 19th deadline, so an early December date seems good to us. Either of those.
December 3rd or 10th work for both sides?
That would be fine with us. Thank you, Your Honor.
Somebody have a preference? Speak now or I pick
3rd.
December 3rd. Okay. One of our former Supreme Court justices' birthday. December 3rd. Justice Silver will be turning 60, in case anybody wants to wish her a happy birthday in December, just to let you know. I'm more kidding about that, but I just was like that. Anyway, okay, so December 3rd, 8:30, status check. Second one, March, April. Is this one I have to work around spring breaks and things like that? That's so why don't you just propose a date? I can go defense first. I want to propose a date in late March, early April. Do you have one in mind? If not,
I don't, Your Honor.
Yeah, we.
Counsel, do you have one?
Oh, I'm sorry.
Yeah, go ahead, Counsel for Plaintiff, if you have one in mind. Whoever has, I'm just realistically.
We could do, how about April 8th, Your Honor?
Yeah, I just didn't want to get it too close to your dispositive motion cutoff date, just in case there was something that you all needed.
Or March 25th. I was looking at Tuesdays, if that works.
Tuesdays or Thursdays, yeah, either is fine.
March 25th would be fine.
Okay, you don't want April 1? March 25th works.
Either one of those dates is fine with me, Your Honor.
Counsel?
March 25th works for us too.
March 25th, 8:30. Okay. So now's the time we walk through whatever else you all would like to discuss to make this a wonderfully fruitful Rule 16 conference for you. With regards to that Rule 16 conference, like I said, we give you a whole long listing of things. That's neither a specific list that you must or a limitation. It just kind of gives people a couple of ideas of different things that need to get discussed. The one thing that is important is if there was any accommodations courtroom wise, that's one thing that we'd like to take care of as soon as possible, but I didn't think that that really applied here. Meaning, if somebody has an access issue, as you can tell, ours doesn't have a ramp, so we either try and get a different courtroom, or there's actually a pre-built ramp that we got from another case that we might be able to move in here, you know, things like that. So we can just, the things that take other departments to try and assist. If that's not an issue, feel free, walk through counsels for plaintiff. What
No,
would you like to discuss?
No, there's no issues that I'm aware of concerning access or like, and this courtroom will work just fine. There are some other things that we'll report to you on, but I'll wait as you go down your checklist.
We don't have any access issues on our side.
Okay. So then I'll open it up to the global. What can we do to make this a fruitful Rule 16 conference for you?
Well, we don't really need the court's assistance yet. I mean, Mr. Wade's team has sent us ESI protocol and some callback language. I've been a little preoccupied on another matter in front of Her Honor, so I've told Mr. Wade I will try and get back to him later this week, at the latest beginning of next week, on those documents. So if we have a disagreement that we can't resolve, which I would think would surprise me very much, we'll bring it to your attention, but I don't anticipate that's going to be necessary.
Okay. Counsels for defense?
We don't have anything that we need the court's assistance with, and the Rule 16 order, everything has been agreed to as it's in the papers.
Okay, you all know that, or probably know, Supreme Court denied rehearing on a case. So, but just remember, since this case is one of the cases, you know, that's generally impacted with regards to certain things being under seal under Supreme Court Rule 3 and applicable case law, as new issues come up, just remember to please give the court enough of a heads up. I will tell you what's happening in a couple of our business court cases, none that any of you all are involved in, is sometimes there's a challenge where people might be trying to file parts of documents, sealed and unsealed. If people have questions about process, we can assist if we need to, but just to make sure you get things taken care of as they need to get taken care of. Because remember, it's an individualized document by document analysis the court goes through. Some people have had a thought that if one gets sealed, that means everything else gets sealed. No, the court has to analyze each and every request for sealing. Okay, and I know that doesn't apply to you all, but I just mentioned it because it's coming up more than once, so I at least wanted to address that. Well, it's great to see you. What else can we do for you? Anything else, counsels for plaintiff?
No, Your Honor, thank you very much.
Counsels for defense?
No, Your Honor. Thank you.
Appreciate it. Thank you so very much.